Okay, let's dive into this. Picture this. You're standing in a foreign travel agency, halfway across the world, ready to finally buy those plane tickets for your family vacation. You confidently hand over your credit card. And it's declined. Ouch. We've all felt that sinking, totally relatable dread, right? But what happens when that sheer embarrassment escalates into a massive multi-million peso lawsuit? Well, welcome to our explainer. Today, as an expert in Philippine jurisprudence, I'm going to walk you through a comprehensive case digest of Aznar versus Citibank, Supreme Court case GR-164273. We're going to break down the facts, the issues, the ruling, and the lasting doctrines enshrined in this case.
Here's our roadmap for digesting this case. First, the facts, a declined card. Second, the evidence battle. Third, the core legal issues. Fourth, the rulings, which is a bit of a judicial roller coaster, trust me. And finally, the doctrine, covering the enshrined legal principles. All right, Section 1, the facts, a declined card.
So every great legal battle starts with a story, right? Our protagonist here is Emmanuel Aznar, a well-known businessman from Cebu. He had these big plans to take his wife and 2 grandchildren on a grand Asian tour. To get ready, Aznar actually made a massive advance deposit of 485,000 pesos right into his Citibank MasterCard account, basically intending to bump his credit limit way up to 635,000 pesos. He successfully buys flights to Kuala Lumpur worth 237,000 pesos, and the family sets off. But the trouble starts when they reach Indonesia. Aznar tries to use his MasterCard at a travel agency in Bali, and it's dishonored. To make matters so much worse, Aznar claimed the agency staff made some incredibly humiliating insinuations, basically suggesting that swindlers often try to use blacklisted cards. He ended up having to pay in cash and came back to the Philippines feeling completely humiliated.
Now, what's really fascinating here is the massive gap between what Aznar believed and what Citibank's system actually registered. Aznar comes home, furious, and files a complaint for damages. He claims Citibank fraudulently or negligently blacklisted his card, causing him severe mental anguish and a besmirched reputation. But Citibank countered, saying, "Whoa, hold on, we never blacklisted you at all." Instead, they argued his card was simply declined over limit. You see, this huge gap between Aznar's personal assumption and the bank's technical reality, that is going to be the absolute crux of this entire lawsuit.
Moving on to Section 2, the evidence battle, proof versus presumption.
So, Aznar sues and the venue shifts over to the Philippine Regional Trial Courts. Now, in civil cases, the law requires a preponderance of evidence. Basically, you have to prove your claim is more likely true than not. To prove he was blacklisted, Aznar presented what's called Exhibit G, a computer printout handed to him at that Indonesian travel agency, complete with the handwritten signature of a clerk named Nubi. It simply said, "Dec over limit." On the flip side, Citibank presented their warning cancellation bulletins. These were official authenticated internal documents listing every single canceled card during Aznar's trip. And guess what? Aznar's card was literally nowhere on that list. It's this stark, glaring contrast between a vague, unauthenticated printout and heavily documented corporate records. And you know, this brilliantly illustrates the fatal flaw in Aznar's legal strategy. During the trial, when pressed on how he actually knew the card was blacklisted, Aznar gave this exact testimony on the stand. He said, "So when it is denied, that's presumed to be blacklisted." I mean, wow. He flat out admitted he had no personal knowledge of a blacklist. He just assumed it. And in the eyes of the law, you absolutely cannot substitute a personal presumption for actual authenticated proof. Which brings us to Section 3, the core legal issues. Finding liability.
So, we're distilling this down to the absolute essential legal core. Did Citibank fraudulently blacklist the MasterCard, and are they liable for damages? It sounds like a super straightforward yes or no question, right? But as you'll see, the journey to get that final answer was anything but simple.
Let's dive into Section 4, the rulings, a judicial roller coaster. Okay, brace yourself for this staggering number. Initially, Regional Trial Court Branch 20 dismissed Aznar's case entirely for lack of merit, finding Citibank's evidence way stronger. But Aznar asked for a new judge. Enter Judge De La Peña of Branch 10. In a shocking reversal, Judge De La Peña ruled in favor of Aznar and awarded him a mind-blowing combined total of 16.2 million pesos in damages and fees. Just incredible, right? But here's the major twist. The Supreme Court later found that Judge De La Peña made this egregiously large, unjustified award while totally ignoring basic rules. They actually suspended him for 6 months for knowingly rendering an unjust judgment. Wild. The Court of Appeals obviously threw out that 16.2 million peso award and reinstated the original dismissal. So Aznar appealed straight to the Supreme Court.
Let's see how the highest court systematically dismantled Aznar's arguments and ultimately sided with the Court of Appeals. Step 1, they reiterated that the burden of proof rests solely on the plaintiff. Aznar alleged blacklisting, therefore he had to prove it. Step 2, Exhibit G, that computer printout, was electronic evidence. Under the rules, it needed strict authentication. Aznar didn't see it generated. He couldn't prove the signature was authentic, and he literally couldn't explain how the data was retrieved, so it was legally inadmissible. And step 3, the court ruled that simply having your card dishonored or declined does not automatically mean the bank maliciously blacklisted you. Without rock-solid proof of bad faith or gross negligence by Citibank, the whole claim just falls apart.
Finally, Section 5, the doctrine, enshrined legal principles.
The Supreme Court applied a classic legal concept here, damnum abscet injuria. In plain English, this translates to damage without injury. Now, this concept acknowledges that Aznar definitely suffered a loss. He experienced real humiliation, embarrassment, and stress when his card was declined abroad. But, and this is the absolute key here, Citibank didn't legally wrong him. They didn't violate a legal duty, they didn't act with malice, and they certainly weren't grossly negligent. Because there was no legal injury caused by the bank, the law affords absolutely no financial remedy for the damages he felt. You kind of just have to bear the consequences alone.
Aside from that Latin maxim, let's look at the broader legal impact of this case. Why does this matter to us? Well, first, it reinforces that if you're going to sue, you must bring hard proof, not just assumptions. Second, it serves as a massive warning about electronic evidence. You can't just wave a random computer printout in court. You have to strictly authenticate who made it and exactly how the system works. And third, there was actually a small win for consumers here regarding contracts of adhesion, like the fine print on a credit card application. Citibank tried to argue their contract gave them blanket immunity for any declined card, anywhere. The court struck that specific defense down, saying such vague, one-sided clauses must be interpreted against the bank that wrote them. However, Aznar still lost the overall case because, well, he simply didn't prove the bank acted negligently in the first place. Which leaves us with this final provocative thought. What actually happens when your assumptions don't match the evidence? Emmanuel Aznar assumed a terrible humiliation was a malicious corporate blacklist. But Philippine jurisprudence demands rigorous, authenticated proof, not just deeply felt assumptions. It's a really stark reminder of the strict evidentiary standards of the law. If this deep dive sparked your interest in how the courts dissect everyday conflicts, let me tell you, there is an entire world of Philippine jurisprudence out there just waiting to be explored. Until next time, keep learning, keep questioning, and always keep examining the evidence.